The final speaker for the sub-theme 2 is Mr. Varian from the Allen and Grid here LLP in Singapore. Mr. Varian, please proceed.
Thank you. Honorable judges, distinguished guests and dignitaries, ladies and gentlemen, good afternoon. I will be your final presenter for this afternoon. And before I start, I'd like to give my congratulations to the IPI Court on your 20th anniversary. 20周年おめでとうございます。And since we're on the topic of anniversaries, I've also celebrated an anniversary this year, and similar to the IPI Court, I've been in legal practice for 20 years, in the same firm, and always in intellectual property. And to borrow the analogy from the distinguished speakers who came before me, I probably started out as a young adult when I started practice, and I'm now into my middle age. And hopefully, as mentioned earlier, with this middle age comes some wisdom that allows me to be retrospective, introspective, and also circumspective in how the laws in Singapore have changed in the past 20 years. I will be referring to some cases from my fellow practitioners in Singapore, and those cases will illustrate how Singapore's countermeasures against internet-based IP rights infringement is actually carried out. So let's begin. So similarly to previous compatriots who have presented, Singapore also has statutes that protect the ownership and use of IPR. Like our Malaysian counterparts, we amended our Copyright Act recently. We did it slightly earlier. That was done in 2021. Our Trademarks Act, Registered Designs Act, Patents Act, and Geographical Indications Act were all passed in the past 20, 30 years. And they've gone through significant amendments over time as we entered TRIPS, certain free trade agreements. In this slide here, I haven't listed all the statutes that protect IPR. We have a Plant Varieties Act as well, but that seldom features in internet-based IP infringement. We also protect confidential information and trade secrets through the use of our general law on equity and confidence. So the way I see it, there are two categories of internet-based IPR infringement activities. And in my experience advising clients and dealing with the courts and policymakers, it's easiest to explain internet-based IP infringement into these two categories. One being the traditional sale of infringing goods, physical goods that infringe IPR. And the solution to that has always been physical countermeasures, and in recent years, digital countermeasures as well. Now, in the past 20 years, in my practice, we have seen that the communication, performance, broadcast of digital content that infringes IPR cannot be effectively met with physical countermeasures, and digital countermeasures have proven to be the only viable solution at this point in time. So let me start with the physical countermeasures. The way Singapore protects its IPRs is by regulating the import and export of physical goods at the borders. Similar to our compatriots in the region, border enforcement is the first line of defense for all IPR owners. It is generally self-help in nature, which is something that a lot of IPR owners have to grapple with when they come to Singapore and deal with our customs and border control. They'll first have to lodge a written notice with customs to see suspected infringing goods. This notice is valid for 60 days, and if a seizure does occur, they must commence action within 10 working days. It is extendable, but only by another 10 working days. So time is running, and you have to move really quickly if you are the IPR owner in order to commence action. In addition, the IPR owner also needs to provide sufficient security to customs to reimburse customs for any reasonable expense or to pay compensation if the goods actually did not infringe IPR. Now, the relevant laws in our Trademarks Act, our Copyright Act, Geographical Indications, and Registered Designs. You might notice that I've left out the Patents Act here. And traditionally, the border enforcement doesn't involve the seizure of patent infringing goods. And so our Patents Act does not provide for that. But Singapore Customs is equipped with the Border Enforcement Measures rules, which are the subsidiary legislation to all this primary legislation that I've spoken and referred to here. Now, nonetheless, Singapore Customs does seize goods in its own official capacity. And on its own initiative, if it reasonably suspects there to be infringing goods, they will seize them and then notify the IP rights holder, who will then have to ask customs to continue the detention of the goods. And again, 10 is the magic number, file suit within 10 working days or seek an extension of 10 working days. So again, the relevant laws in relation to trademarks, copyright, geographical indications. Oddly enough, our Registered Designs Act was not one of those acts that gives the power to Singapore Customs to seize goods on their own initiative. Now, I want to talk about this case here that happened quite a number of years ago, involving a significant number of brand owners and a particular shipping company. Most of you may know that Singapore is a transshipment hub in the region, and our physical countermeasures also extend to goods in transit at our border. So these are goods which are not intended for Singapore as the final destination country, but border control can seize these goods if they do infringe IPR. So our Court of Appeal, in this case, found that goods in transit can be considered to be imported for the purposes of the Trademarks Act. And I would suggest also for all other acts that allow border enforcement, as long as they infringe IPR. Bearing in mind that this case involved unique laws and practices that are particular to the shipping industry, the court was mindful that freight forwarders operating in Singapore who handle these sealed containers with no knowledge of their content would not be liable for the importation and subsequent exportation out of Singapore. So together with the Singapore Police Force and Singapore Customs, they do conduct joint border enforcement operations to stop the importation of counterfeit goods. These have proven to be extremely effective, and our authorities do provide with the media releases ever so often to inform would-be infringers, counterfeiters, that the police are watching and will take the necessary action. Now, notwithstanding that, we also have consumer protection legislation in Singapore that imposes restrictions on the sale of goods that are falsely described or advertised. While not strictly intended to protect IPR, our Sales of Goods Act does state that where there's a contract of sale by description, there's an implied condition that the goods will correspond with that description. So arguably, this law can be used to provide civil remedies for the purchase of counterfeit goods. Likewise, we have a Consumer Protection Fair Trading Act, which says that it is an unfair practice to deceive or mislead consumers. And this can also lead to civil action and also administrative tribunal action from the Consumer and Competition, the renamed Competition and Consumer Commission of Singapore. So now I will move on to digital countermeasures against the sale of physical goods. Now, for those of us who have been in the practice of law all these years, these measures will not come as no surprise. I've constantly advised my clients, let's commence action to obtain an injunction against the seller to stop the sale of infringing goods. And likewise, with the earlier presentation from Honorable Justice from Korea, Singapore also does allow for statutory damages against the seller under the Trademarks Act. And that was illustrated quite effectively in this case, involving the well-known brand Louis Vuitton and a particular individual in Singapore in the year 2025. So this is a very recent case, and it shows how social media networks or SNS can be used to infringe IPR. In this case, the defendant operated an online store via Instagram and specifically targeted towards the Singapore market, as you can see from the suffix SG in the account names. So those goods had counterfeit marks of the claimant. The claimant became aware of such infringement and commenced action for trademark infringement. Unsurprisingly, the Singapore High Court ordered an injunction to prevent the defendant from continuing the infringement via the Instagram accounts. Now, the defendant in this case did not take part in the proceedings, and therefore it was quite difficult to obtain discovery and information of the type of damage that the brand owner did suffer. And what the claimant did in this case, my learned friends in the bar in Singapore, they asked for statutory damages instead under the Trademarks Act. And the Singapore High Court recognized that statutory damages had been legislated as an alternative and perhaps more convenient remedy to the traditional account of profits, which is to prevent unjust enrichment, or for traditional damages which are compensatory in nature. Now, when you are unable to provide evidence of your own damage, perhaps because of the non-compliance or non-cooperativeness of a defendant, the statutory damages will actually allow the claimant and obviate the need to prove actual or foreseeable loss as a result of infringing activity. And this is particularly useful when the claimant lacks the evidence relating to the loss. And this is a bit more interesting because this is something that is not a settled point in most of the countries in the region. What kind of countermeasures, legal countermeasures, are available against the intermediary platforms, which perhaps facilitate the sale of these goods to infringe IPR? The earlier case talked about infringement via Instagram, and there are two types of intermediary platforms: the marketplaces and social media messaging apps. So just to be clear, there is no clear legal liability for intermediary liability on such platforms. Typically, they are functioned as middlemen, and the situation may be different nonetheless if a platform sells products under their own name. Now, nonetheless, our government has, in relation to intermediary platforms, given a rating system based on user authenticity, transaction safety, available of loss remediation channels, and effectiveness of anti-scam measures for such online marketplaces. While not specifically designed to protect IPR, you'll see that from the rating system, the TSR as we like to call it, they do have a variety of factors that the government will give in order to decide whether an e-commerce platform is safe. And you'll see that a number of familiar e-commerce platforms are there. They are ranked accordingly, and this is publicly available, correct, as of September this year. So the question that remains is, what kind of legal action can we take against social media and messaging apps? In theory, they can be held liable under the common law tort for authorization of infringement. But this is tremendously difficult to prove, given that these companies tend to distance themselves factually from the sellers of the goods. And takedown notice that they employ is a useful factor to suggest and prove that they have nothing to do with their sellers. Now, more interestingly, and like our compatriots, we also have something similar to a site blocking order. We call it an access disabling order, and in Singapore, if a website is deemed to be flagrantly infringing online location, the internet service providers in Singapore's ISPs will be ordered to block the access by users from Singapore. This is only in relation to copyright. Now, what is important to note is that notwithstanding there's an injunction against a particular online location, this injunction is dynamic in nature, as the ISP from time to time, it should block new means of accessing the online locations which contain the same infringing content. While not specifically legislated by our parliament, in the case of Disney Enterprises, our courts did allow for a dynamic injunction order and found that this was consistent with the Copyright Act. So just for evaluation, the physical countermeasures, which seizures on request and official action, have been very effective, and the digital countermeasures in relation to the sellers of goods and the ISPs have also been effective. The question I have for the future is really, should intermediary liability be statutorily imposed? And should we also legislate for disabling orders and dynamic injunctions in relation to all forms of IP in Singapore? I have run out of my allotted time, and I thank you for your attention. Ijo deshita.
Thank you very much, Mr. Varian, for your presentation.